Montgomery County Public Library.
Morning, Judge.
Morning.
Morning, Your Honor.
Montgomery, Plaintiff.
Jeff Neenan with the Library Board, Your Honor.
Michelle Williams.
All right. First of all, two issues. Number one, there are two cases pending, one in Kent, one in Campbell, that there is no decision on yet. So, you know, I think whoever decides the case needs to wait until that is decided. But the other thing is that the canons of ethics say that no judge shall decide a case if you have pecuniary interest in the outcome of the case. I own a couple pieces of property here in Montgomery County. That makes me have a pecuniary interest. I don't know that any judge who owns property in this county should be deciding this case.
Because we had that, the Campbell and Kent cases originally, the libraries had moved to federal court, and Judge Bunning resides in Campbell County. And he brought that up, and I remember Mr. Manheimer that there was a discussion of a de minimis, because it'd probably be difficult. I think Judge Stummy even brought up the issue, because obviously most judges own property, own their home, and there was always a discussion about it being a de minimis benefit. I mean, Judge Stummy, I think, echoed concerns that you would end up, you could be where no judge could preside, because like right now the issues in the Court of Appeals for Kent and Campbell, and you know, I think most of the appellate judges also own property. So I just kind of thought what we've seen.
Well, we don't have any appellate judges that own property in Montgomery County that I'm aware of.
Judge, as far as we're concerned, we appreciate the disclosure. We've waived any conflict that the court perceives that we might have. We're comfortable stating on behalf of the Library Board.
Okay. So, where are the Campbell and Kent County cases in process?
In the Court of Appeals.
Right, but how long have they been pending?
We originally, by agreement, tried to use the transfer rule to take the case to the Supreme Court, because that's where this case is headed at some point. Supreme Court.
Instead of waiting on a decision, then file a motion for discretionary review.
Right, we just asked to transfer it because of the urgency, because this has a statewide impact, 80 libraries across the state. The Supreme Court, however, decided not to accept transfer. They remanded it back to the Court of Appeals. We have a motion for intermediate relief pending in the Court of Appeals that's been pending and briefed for, on a Campbell case, for almost 60 days. So we're waiting on that ruling. Kenton is a little bit further behind. We anticipate that the Kenton case and the Campbell case will be consolidated, and then ultimately, I can't say when, we'll get an appellate ruling at that level. But it's going to go to the Supreme Court, we hope, at some point.
Which may be several years.
We've asked it to be expedited, but
by agreement.
By agreement.
I think the Supreme Court has time to hear it. You know, from what I know about their caseload, I think they have time to hear it. The Court of Appeals, on the other hand, is backed up. So I wish that they had accepted transfer.
Your Honor, as we said in our statute court, we felt like in terms of this case and how it should proceed, at least in the short term, it seemed to make sense for all the parties, saving attorney fees, costs, judicial economy, to have the case be held in advance, at least till we get an appellate ruling on which statute governs the funding and the setting of ad valorem taxes for libraries. It just doesn't seem to make sense to me to go forward and litigate, spend money, go through potential class act certification until we get finality on that pivotal issue.
What's your position on that?
Judge, I guess I spoke with my clients. We kind of see it both ways, and you know, yes, there is some judicial economy to that, but as Judge Stummy referenced, there's also kind of a good idea to have numerous circuit courts weighing on the issue, so you have a stronger record that's up at the Court of Appeals. Because, you know, for example, the Kenton County case has really two issues. There's actually a cross appeal by the plaintiffs on whether or not you have to seek an administrative refund. One of the concerns I have is you could end up where sometimes a higher court decides a very small issue and the overall issue doesn't get addressed. So I do believe there is some benefit to going ahead and having at least the same way we handle Kent and Campbell. The court addressed the declaratory aspect of the case. Does House Bill 44 apply, or does KRS 173-790 apply? So that would be the way my clients would like to proceed. The other issue they have is, you know, they're of the opinion that the tax rate they would like to tender in escrow to the sheriff, you know, the difference, because, you know, while everybody says, hey, you can get a refund, they also have a belief that if government is passing a tax they shouldn't be, that they shouldn't have to keep tendering that because something's on appeal at the courts. They have no problem tendering the money, they would like to escrow with the sheriff. And that's one of the issues where, well, we haven't applied our motion yet in Campbell. That's one of the issues we're bringing forth in Campbell County, because the library is still going to use the same tax rate, even though Judge Ward ruled that granted our declaratory judgment that 790 applied.
Your Honor, in certain courses in Campbell Circuit Court cases, the judges have both denied those motions to escrow or require the libraries to escrow the funds, because it's just an end-around way of giving them the relief they want and taking away our appellate rights that we have in order to get a final decision on which statute governs. And so those motions were denied. In this particular case, we would certainly be opposing that if a motion were filed and require the library to escrow those funds.
Is there any discovery that needs to be conducted?
Not on the pivotal legal issue. I mean, if we get beyond the pivotal legal issue, Your Honor, for example, if you would rule in favor of the plaintiffs in the case about 173-790 governing the setting of the tax rate, and then we would move on to whether they can maintain a class action, that would kind of be a legal issue too. There could be some discovery that perhaps could be involved there. But if the court is not inclined to hold abeyance, then I would agree with Mr. Volker that the first issue for the court is purely a legal one, and that is to decide the question of which statute governs, and then we can come back. But I still believe that it's best just to hold the whole case in abeyance until we get appellate guidance.
All right. I'm going to take it under advisement right now as to the issue of abeyance versus going ahead and making a ruling on those two statutes, and look at it more in depth. What I didn't know today was whether, if I went ahead and did all the research, whether you all were going to say, well, you're right on the recusal, and then somebody else was going to be having to step in and do it all over again. So I want to take a look at that and issue an order as to whether I think it's best to proceed now or hold it in abeyance until the appellate is decided.
Your Honor, if the court ends up deciding that it should go forward, perhaps in a permanent fashion, that ends up being the case. I assume you'll set a briefing schedule that allows us to brief that. Sure.
And I think we can brief it fairly quick.
I already have those on hand.
We
I have a feeling
it's going to be the same.
inserting names and different.
Although my arguments, you learn what you can do. So, but we got it already.
So I'll enter an order as to whether they'll need to submit the brief and the briefing schedule, or whether we're going to just hold it.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
Thank you.
Have a good day.
Let's take this off. JP Morgan Chase versus Josh Roth.